Okay, welcome back. We're here on the beach and I'm joined by my friend, Attorney Matthew Underwood. Matt, thanks for joining us today.
Thanks for having me, Tom.
And I saved another difficult question for you. Matt owns and operates Underwood Legal LLC, a boutique estate planning and elder law firm in Madison, Wisconsin. And I have a good probate question for you today, Matt, that came in from a reader. And the reader writes the following: can a personal representative accept a home offer of a will that is part of 3 kids? He is one of the kids. The offer is $15,000 under market value. So what do you think about that, Matt?
So there's a few things going on in this question, but I think the first part is that this is a fairly common situation that we see. We often see cases where mom and dad set up an estate plan, where if mom and dad both pass away, then one of the kids would take over as the personal representative and administer the estate. So I think it's fairly common to see that where we might have 3 kids, but one of them was named as that personal representative. So really the personal representative is the person who has the legal authority to administer the estate. And the personal representative is actually appointed by the court. So they would get letters from the court giving them authority to handle the estate. So in the personal representative's authority, one of the things they can do is dispose of property. So they can sell property, real estate, they can sell stocks and convert that to cash. So the short answer to this question is the personal representative can accept offers on that house. They do have that authority to do so as long as they're appointed by the court. But the slight twist to this question is, can they accept an offer that is $15,000 under the market value?
Yeah.
So market value, in a lot of ways, valuation is more of an art than a science. So you could have 3 appraisers take a look at a house and you'll get 3 different valuations from each person. So in my mind, when people are coming up with a market value, it's always an estimate. It's using our best judgment and our best guess, but only by listing that property on the market and starting to get some actual offers and people interested, that's when we're really going to know, what are people willing to pay for that property. So I think, maybe that market value, it's out of date, or it just doesn't reflect the actual market conditions. So it's, I think it's okay for the personal representative to potentially accept an offer that wasn't what they expected or not fair market value. But the one cautionary tale to that is I would highly recommend that personal representative talk to his siblings and make sure that everyone's on the same page and that siblings are okay with him accepting that lower offer. That'll avoid any sort of potential disagreements down the road. So I would really encourage that open communication with the other heirs of the estate. So I think in my mind, the best way for that personal representative to deal with this situation is to speak with a qualified estate planning or probate attorney. And that attorney is really there to provide guidance. So if the personal representative wants to handle a lot of the work of the estate and be the person that's really dealing with a lot of things, that's fine. And then if there's questions that come up that personal representative is not really sure what to do, that's a perfect place for the attorney to come in and then offer guidance on that. So I do really encourage this personal rep to get some other help on this as well.
So Matt, I think that was a great answer. But what I heard you say here is that personal representative, if that's the person named in the will, they're really in charge of managing and selling that real estate, correct?
Yeah, that's correct. So just being named in the will, that doesn't give that person authority to act. We really need to give that will to the court and then get a letter from the judge, that letter of authority saying that, yep, this personal representative was accepted and personal representative can now, take action on behalf of the estate. And that's called the domiciliary letters in Wisconsin. So those are the letters that the personal rep is going to get from the court.
So really, your other point is a good one. Try to talk with your siblings and get consensus on this house sale, right? But if there's a disagreement, ultimately the court, correct me if I'm wrong, they're going to look to that personal representative as the decision maker, correct?
Right. So if there is a dispute and, maybe siblings can't agree on what to do, that's what the court is there for. The court is kind of the last resort on where those disputes can be resolved. So, I think in that case, the judge is an impartial person. So they're going to look at all the facts to the situation. Maybe that personal representative is trying to sell the house to their best friend and trying to give their best friend a really good deal on this house. So, a judge might say, hey, that's not what you should be doing as a personal representative. So, so I think, it really depends on the facts and circumstances and, what's happening overall. But you're absolutely right. There is a way to resolve those disputes. It's just that, does the family want to get together and resolve it on their own? Or if they can't, well, then we need to get a third party involved to help with that.
Right. Well, great question to the reader. Thanks for writing. And thank you, Matt, for that comprehensive answer.
And thanks for having me, Tom.
Thank you, everyone, for watching. That's all for today. We'll see you next time.